Hello and welcome to The Big Picture. For the second time in our country's history, a former Prime Minister has been put on dock for their official actions. However, Dr. Manmohan Singh being named as an accused in a case of alleged illegal allocation of a coal block seems different from the three cases faced by another former Prime Minister, P.V. Narasimha Rao. It is for the first time that a Prime Minister's action in taking a decision in his official capacity, in this case as the coal minister, has come under question. The case itself will now be tried and the merits and demerits of the case will be argued and decided at a later date. However, the question which has cropped up, as Dr. Singh himself in his defense in 2013 had raised, should administrative decisions and government policy be a matter of investigation if mala fide is not evident prima facie? Also, what would be the impact of Dr. Singh being put on the dock on governance, decision-making and business environment? Also, the more crucial question, does this action of the special CBI court to name him as an accused display the robustness of our judicial system, or is it judicial overreach? We will discuss all this with an eminent panel of guests. I have with me Soli Sorabjee, former Attorney General of India and a distinguished jurist, T.S.R. Subramanian, former Cabinet Secretary to the Government of India, Dr. D.R.Karthikeyan, former Special Director CBI, and Sanjay Kapoor, Editor Hard News Magazine. Welcome to all of you. Mr. Sorabjee, is this decision of the special CBI court, should we consider it as an indication of a robust legal system, or is it judicial overreach?
Well, without knowing the facts, I can't give a definite opinion. But I'm extremely surprised and upset, because I've known Manmohan Singh when I was Attorney General, when I was out of office. He's a man of exceptional integrity, and I don't think he'd be accused of any wrongdoing. Maybe some technical breaches, but there's no question of any dishonesty. I find it difficult to believe.
Okay, I mean, that is a...
Maybe the CBI judge thought there were facts and did it. It's a different matter.
Okay, sir. I know we will come to the facts, but that seems to be a very ringing endorsement of Dr. Manmohan Singh. Mr. Subramanian, how would you look at this?
Well, I have tremendous respect for Mr. Sorabjee, but firstly, he is a retired public servant. And there is no question of distinguishing the law. Manmohan Singh. The law ought not to distinguish between A and B, number one. And number two, I heard today the most absurd statement of this decade. Last decade, the absurd statement was zero loss theory. This decade, for me, the most absurd statement was that the rule of law is in crisis. And that from a former law minister. I'm very sad to see this. Does a trial judge not have the right to look at the investigation report, come to his own conclusion if a prima facie case is made out or not, at least whether the person should be called to clarify his position or not? What does it matter if it is except for probably the president or the vice president? What does it matter? Who else is it? Is there something wonky in our thinking that should be different? One final point here. The crux of the issue is not mala fide, unless you change 16A of the PC Act. The crux of the issue here is, if knowingly you cause loss to the public exchequer, there's no need to prove or even to allege that you are personally involved in any wrongdoing. In this case, 15% was handed over which belonged to Neyveli Lignite Corporation without following the procedures. And the procedure of the day was the steering committee without following the procedure. That's the crux of it here. So, prima facie, a case is made out. So, the normal principle jurisprudence is, I hesitate to speak before Sorabjee. Normal principle is mala fide, mens rea. But 16A deliberately has an antidote for that. So, I would say, I think law should take its course. It is not earth-shaking. If cancellation of 200 licenses, cancellation of 2G did not shake the country, we are back again into normal. The PM being called to explain his position, he should have explained it to the public 3 years back, 5 years back. The public should have known word to word. And in 2G, we did not have the Parliament committee examine Chidambaram, examine Raja, No, is there RTI? It's an open system, it's a highly closed system. The public should now know all the facts. If it is through the court, sadly, so be it.
Okay, I mean, that's interesting. Mr. Karthikeyan? Mr. Karthikeyan, how would you look at it? I would like to go back on what Mr. Subramanian said to Mr. Sorabjee, but I would like to hear you first before I go back to him.
You see, the whole day I've been busy. I have not followed what is happening on the television comments of various people on this issue. I mean, I entirely agree with Mr. Sorabjee that Dr. Manmohan Singh enjoys the highest and widest reputation for personal integrity. There's no doubt about it. Now, then I just spoke to the director of CBI, Sanjay Sinha. He says, earlier they did not examine Dr. Manmohan Singh, but that the court wanted the investigating authority to examine him. After that, I believe that they filed a report with statement in the court.
Right.
And the CBI didn't say, CBI original statement was that there is no evidence of any criminal liability.
There is no criminality involved.
No, that's right. But thereafter, there is no comment. They simply submitted the statement of Dr. Manmohan Singh, which was examined later on and submitted. Now, the court on its own, having gone through all the papers, they have taken a decision to summon. Now, the question is, as I told you personally, I mean, everybody will be surprised because he is known for his integrity. But now what is the way out? The remedy lies in the court itself, If there is apparently, there is some people find it's, total absurdity in the order or whatever it is. We be very careful when they talk about court orders, and otherwise it will be contempt of court. But certainly the remedy lies only in the court. Remedy lies in the court, same court or higher courts. Okay. Now, there is no use of debating the issue.
Absolutely. No, sir, my question...
or on the streets or in the, television studios or anywhere else because, that is the way, our system functions.
No,
the court has taken a decision.
I entirely agree.
Lies in the same court or go to higher court.
Go to higher court. I entirely agree with you, Mr. Karthikeyan, but one question which bothers me is that, the CBI twice told the court and in its final report said very clearly that there seems to be no criminality involved. I don't think they didn't think that former Prime Minister Manmohan Singh should be brought in as an accused. They made it clear. The fact that the special CBI court rejected their contention and went ahead and made him an accused and has now done, does it reflect on the integrity or the functioning of the CBI?
No. See, CBI has come to a conclusion telling there is no case. But ultimately the decision is with the judge. He can, see, if you recall, Arishi murder case, the CBI filed the final report telling there is no evidence. But the same court converted on this very final report. They said no, they stay in charge for not only for causing disability, even for causing murder. It went up to the higher courts also. Now ultimately they're facing trial. See, what the CBI says is, we have done this investigation. These are the facts which has come out. And in our opinion, there is no case made out. There is a final report is filed. But ultimately, the decision lies in the court. Absolutely. The judge has to accept it or reject it. He has got a right to do that.
Right.
Now, the thing is, if it's widely felt it is not called for when the CBI has said there is no case at all, now summons have been issued. I personally believe that remedy lies in the very court. It can be gone back and explained to the court telling, I mean, there's an error of judgment or whatever it is to say that is not correct, it should be withdrawn.
Okay, sir.
Or go to the higher courts. There's no other way you can deal with it.
Absolutely.
You can't blame the CBI. The CBI has said there's no case.
Okay.
Normally, we blame the CBI. CBI is politically misused and all that. In this case, you can't say that.
Well, the people are still saying that because the CBI wanted the case to be closed and it said that there is no criminality. The people are still questioning the CBI. But anyway, we will come back to that. Mr. Sorabjee, how would you react to Mr. Subramanian? And one more thing, I just want to read what the special court judge has said before asking Dr. Manmohan Singh to be made an accused. He says there is complete disregard. I'm quoting from what the judge has said. Complete disregard to the direction of law, rules, regulations, and guidelines to accommodate Hindalco in Talabira 2 allocation in 2005. And he says that Dr. Singh took undue interest in reversing the decision not to allocate Talabira 2 coal block to Hindalco. And he also says that, about Birla, and he says prima facie, it is clear that the impugned criminal conspiracy, which was initially conceived by Shubhendu Amitabh and D. Bhattacharya and Kumar Mangalam Birla and Hindalco, was further carried out by roping in P.C.Parakh, who was Secretary Coal, and thereafter the Minister of Coal. The Minister of Coal was Prime Minister Dr. Manmohan Singh. Mr. Sorabjee?
Well, two things, let's make it clear.
Yes.
I think the CBI can't be faulted for coming to this conclusion. I don't think it was pressurized or anything. It came to that conclusion and made the report. But the final report is not conclusive. The judge has a right to take a different view, but there should be for cogent, substantial reasons.
Okay.
Now, I don't know what the judge says about this. It was undue interest. I cannot say anything because I haven't seen the papers. But I hope the CBI judge wasn't carried away to show his judicial independence and therefore summoned Dr. Manmohan Singh. Maybe it's a weakness on my part because of my high regard for Manmohan Singh, but of course law is no respecter of persons. No respecter of persons. But I agree the best remedy is to take the judicial remedy.
Okay. Okay, sir.
Discussing of the Rajya Sabha television won't take us anywhere.
Okay, sir. I'll come back to. There are a couple of other issues which I'll need you to talk about. Sanjay, how what is the attitude now in the bureaucracy? Especially there are two kind of things. One people saying that these kind of decisions these kind of decisions of the court will put the political class, the political executive on their toes. They will not indulge in these kind of things. These are warning signals to that. The second argument is that these kind of cases, these kind of what some people call as judicial overreach, may paralyze the functioning of the government.
I mean, if you look at it,
I would like Mr. Subramanian also to respond to it.
Okay.
Yes.
I wanted to say that I'm really not shedding any tear for Mr. Manmohan Singh and the other panelists, Dr. Manmohan Singh and others doing it, because I think he created a policy environment where so many scams took place. I mean, I've been covering the entry of Dr. Manmohan Singh as firstly the finance minister. You had the security scam, and you had number of such things. Dr. Manmohan Singh, because of his very high integrity, and everybody said that he's very upright, which he might be, but he never stopped anybody from doing whatever they're doing. I mean, so many scandals took place under his reach, or under his oversight. So if something like this has happened where the the judge feels that Prime Minister Manmohan Singh per se should be an accused, I think he may have a reason to ask him question as to why such a big scandal per se took place. Because parallelly, if you look at it, there are coal auctions which are going on. They have raised about 200,000 crores there. Lakh crores, 2 lakh crores have been raised. So you can draw a distinction about what went right and what went wrong during Manmohan Singh's time. So when you are coming back to your question about the bureaucrats feeling a bit, you can say, threatened by judicial overreach, I mean, this is an issue which has been going around for the last 2-3 years. When you talk about policy paralysis, it was primarily because bureaucrats did not want to take any decision, because CBI was actually staring down at whatever they were doing,
And the CAG.
And the CAT. And, and the CAG, yeah. But having said that, I personally believe that people who are on the right and who stick to the standard operating procedures, the guidelines, they would not have anything to fear. But there is a fear in the system which is unlikely to go away till the time there is assurance coming in. And I think at the time when Mr. Prime Minister Narendra Modi came in, he sent out a message that he would stand by all the decisions that Joint Secretary and above and whomsoever takes, even Director and above they take. But I don't know how the system is going to function. And I see a bit of merit in what Dr. Manmohan Singh said, that if there is, people start questioning even prime ministerial decisions, then how will a prime minister take decisions, at any stage? And so there is, I'm certain about, you can say a display of ambivalence about what is right and what is wrong in an environment.
Let us get somebody who was sat in that seat, Mr. Subramanian. Prime Minister Manmohan Singh in 2013, when he laid his case before he said that, the appropriate decisions which appear sensible ex ante may ex post turn out to be faulty. And also he says that errors of judgment should be distinguished from a criminal act. But is this going to be the guiding factor? Now, as far as the CBI, special CBI court is concerned, whether the court should look at all these issues?
Well, my own feeling is that once upon a time, the administration had plenty of discretion to play with. And nobody questioned it. The court never came in. Even Vinit Narayan case, it went up to a point, it did not go beyond that. And Justice Verma was very keen to go further. It did not go beyond that. But there has been complete abuse of discretion. Postings and transfers are rampant. Any district magistrate who interferes with the coal mafia or mining mafia is transferred overnight. Everywhere we found 2G, discretion was completely. So I think once you abuse the powers given to you, sadly the system says this is now public property, this is public decision making, and therefore this is the boundary. Don't you can be run out by 1 mile or by a quarter inch, and therefore don't cross that line. Unfortunately, the executive has lost the ability to use its own discretion, and unfortunately it's very sad. Therefore flexibility comes out here. In this case, just look at this, give me half a second to examine one aspect of this case. PM agrees that coal should be auctioned. But that decision is postponed for 8 years. Till all 200, the entire cupboard is emptied. Then the rule comes in to auction it. At that time, there is no more mine to be auctioned. Yeah. Now, so the rule now is, we have a screening committee. So we now move to a rule-bound kind of an area. Once you have a procedure, once you have something which is wrong going against the existing decision of auction, and that procedure is bypassed, and clearly, apparently, I have not read the judge's order now. Apparently, within 3 days, there were 10 directives that give it to me today. There was apparently some, I don't know what the details are. So I think now, therefore, we have to take the microscope and see, have you followed the procedure exactly? And if you have not done that, there may be no mala fide, but you are wrong. And unfortunately, 16A kicks in here because there's no loss to the public area. So here, this is more a technical offence.
No, there is a loss of public area because that public sector,
yes.
Navally, yes.
In fact, the judge says that there is a loss to the public exchequer.
That's right.
He doesn't. Of course, he doesn't quantify the loss.
The basic crime is that.
One more point on the other side. On the other side, I don't think the civil servants. I have discovered this, that so long as they write their hands off, write whatever they feel is correct, and whatever minister says, put it down on paper, they never get into trouble. But the problem comes when they start tangoing with the minister. At that point of time, then they have problems.
Mr. Parakh is also in the dock now. Mr. Parakh says that, all these are lies and things like that. But I have a more important basic question to Mr. Sorabjee. Mr. Sorabjee, what constitutes mala fide in this case? Or what constitutes mala fide at all?
Well, it depends on the... Well, look, there are 3 things. Error of judgment, negligence, and deliberate intention to take a decision which would inevitably cause loss to public revenue.
Right.
Now, I wonder on which 3 categories this falls. It may be in 1 or 2 or both. So without knowing the full facts, it's very difficult to come to a conclusion.
No, what about
But I agree with Mr. Subramanian that...
Yeah, please continue,
yes,
sir.
Yes.
Please continue.
Go on.
No, please continue, sir.
No, I want to say that I agree with Mr. Subramanian that an honest, courageous bureaucrat has nothing to fear.
Okay. No.
I don't believe there should lead to any paralysis.
No, but what about... Sir, what about... No, 2 things, sir. Yes. One, Ranjit Sinha, the former CBI director, while not allowing, dismissing, saying that the case should be closed, he said that, that they don't have, the CBI does not have the right to question government and administrative decisions. How do you look at this? In fact, I want Karthikeyan also to come in on this. First, you, Mr. Sorabjee.
No, that depends upon the decision. If the decision is palpably outrageously erroneous, it should be speak of It will show, in one sense, some kind of malpractice. It will be indicative of malpractice.
So, but in this case on prima facie, from whatever you have read and heard, do you see that mala fide?
No.
Okay.
At the most, it may be negligence.
Okay.
No malpractice.
Okay. Mr. Karthikeyan, coming back to the Mr. Ranjit Sinha's assertion before he said that before he suggested to the recommended to the special court that the case be closed or not, or at least there is no criminality involved in this. He says that CBI does not have the right to question administrative and policy decisions. How do you look at this?
See, CBI is not expected to question or examine the correctness or otherwise of administrative decisions. CBI is tasked to investigate an offence. But during the course of the investigation, if it becomes necessary to examine the fairness or malafide or bona fides of an administrative decision, it has to be done. You can't avoid it. During the course of the investigation, if it becomes necessary to examine your particular decision has been bona fide or malafide, it has to be examined because it is not, by itself, CBI has no authority to question the administrative decision at all. There is no jurisdiction. But during the course of an investigation, that too, supervised, monitored by the higher courts in the land, and the courts insist on the CBI to examine all aspects of the case and then put up a report for them. How can the CBI say, I will not examine administrative decision?
Okay. Mr. Subramanian, Ranjit Sinha in fact said that cabinet and government decisions CBI didn't have the authority to question.
The first issue is, I don't think CBI has the authority to question the bona fides of cabinet or bona fide government decisions. These are policy decisions.
Right.
The question is, in implementation of that policy, are we deviating or not, which is a factual question. If the deviation takes place, as Mr. Sorabjee said, is it accidental, is it negligence, or is it something more? Is there something behind the scenes? I think that obviously will be subject of examination. So therefore, on implementation area, but policy decision, I don't think anybody, that is final. Cabinet decides,
so I want to
you can't go behind that.
I want to come in here. On the 2G issue, the CAG got investigated, looked into the when they were doing performance audit, they looked into how the entire 2G thing was handled. And that was a policy decision not to auction at that point of time. Right. So the fact of the matter is they decided
even in this case, that is what
so when they were conducting a performance audit, when they were conducting a performance...
even in this case, they are arguing that they were just following what was the government policy.
So if there is a policy environment which is created in which you decide whether you want to auction or you don't want to auction, and subsequent events suggest that what you did was wrong, whether you can be hauled up for a decision that you took in that particular policy environment. I think that is a matter which Manmohan Singh is also raising.
The auction or no auction policy is not
the issue.
It may be in other cases.
Yes.
There may be other cases in which this is involved.
Right.
In this particular case, the issue was a particular procedure has been prescribed in the absence or prior to the auction kicking in. And was that procedure stuck to? If not, why was it deviated? Was there adequate justification or reason? In what manner was it done? I think this is a very legitimate area for examination.
No, but that's right. But legitimate
there is another thing I want to ask.
The key there is malafide. No, unless there is malafide, do you go ahead?
This is the point I'm making. Because the moment loss to public exchequer comes in, the concept of malafide is not in 16A or P.C.Parakh.
Right.
And that's a key point.
No, but the investigating agency says that there is no criminality in this. And then the court says that there is criminality.
See, if now there's no criminality from the IPC point of view, perhaps, or in terms of conspiracy, etc. Because the question comes, if conspiracy, but if there is a criminality in the sense of a special act, the PC Act, 16A criminality per se says knowingly and willfully causing loss to public exchequer, with or without quid pro quo. So in other words, there's no mens rea involved here, knowingly and willfully causing. Here, clearly it was knowingly, it was willfully, and I agree entirely, his public reputation is so good, nobody can question his personal integrity.
Right.
But here we are talking about public integrity, that's the question we are talking about.
Okay, Mr. Sorabjee, what is it? If both you and Mr. Karthikeyan mentioned that a judicial remedy has to be found to this, which means that you go to a higher court, you appeal against this order and things like that. Now, what is it that the higher court is going to look at in this case?
Look, that's very hypothetical, and I'm going to give legal answers to legal questions.
Sorry, sir?
But I would like to follow up on what Mr. Subramanian said.
Yes.
Bona fide error of judgment, negligence, or if the decision is so outrageous, so palpably wrong, that bespeaks mana fide. It itself reeks of mana fide. In such rare cases, of course you can.
You can look into policy decisions in such cases, where there is very clear case of, mana fide.
Mr. Karthikeyan, when you spoke about, when you said that a judicial remedy has to be found to this, as far as Dr. Manmohan Singh is concerned or his co-accused are concerned, what is it that now that the CBI has taken a certain stand, the court has taken a different stand, completely opposite to it, do you think that the higher courts will have to look at what the CBI said before they can take any decision on this, or is it just the decision taken by the special CBI court?
There are experts like Ms. Soli, Sorabjee are the best people to answer this question. But in my limited knowledge, I think if the affected parties believe that there is absolutely no justification, it's to summon them. The thing is, you can go to the same court. I think the best thing is to appeal to the same court to say that there is no justification for this because there is no material at all. CBI finding is only one aspect of it. The court is not bound by CBI's finding. CBI has a wisdom, the court has the discretion to accept it or reject it. As I told you, in our murder case, the CBI wanted to close the case.
Right.
But the judge said no. On the basis of the same report,
right,
on the same evidence which they have pointed out, they said no, they have to stand trial for murder and all that, ultimately it went to High Court, Supreme Court, ultimately they are facing the trial.
Okay.
So it is not what the CBI says, is only one aspect of it.
Okay.
No doubt important factor.
Yes, Mr. Subramanian.
Through you, I want to ask...
Can go to the same court and then plead telling that there is an error of...
Yes, sir.
And say there is an error of judgment.
It happened in the Airtel summon also.
Mr. Subramanian has a point.
No, through you, I want to ask the president, take the advantage of the presence of Mr. Sorabjee. In this case, the judge has taken a view. He has given a speaking order. I have not read the order. He has given a speaking order. Now, if in public we criticize the order and say it is wrong, it's one thing to say disagree and go on. But to say it's absurd, he is innocent, would it amount to, because we are now going directly to him, would it amount directly, indirectly to contempt of court? Yes, you can appeal against it. You can, but to say, for example, Congress party to say that we are going to file an appeal, they are not accused now. Are they already owning the blame now for the lapse? Now, the technical question is, if you are now impugning the order, a very specific order, questioning jurisdiction or the merits of the order, etc., without taking a judicial route, would it tantamount to contempt of court?
Mr. Sorabjee, would you like to answer that?
Yeah, very clearly. Not at all. Not contempt of court, because you're not attributing more motives to the CBI judge. Is perfectly open to say that the order was erroneous. Perfectly open to say the order was not justified. It can't be contempt of court. It would be contempt if you attribute motives to the judge.
Okay.
That's a different matter.
Which is overreach, for example. Judicial overreach can be that.
Okay. One minute.
Yes, sir, quickly.
Let me make it clear.
Yeah.
Just 1 minute. When you say go to the same judge, it would be go by way of review.
Right.
It means by way of review.
Right.
That may not be a very efficacious remedy. The best thing is to go to a higher court.
Okay. Okay, sir.
To go to a higher court and say the order is completely unjustified. Okay. But I don't think Dr. Manmohan Singh would take that route, because it would appear as if he wants to concede things.
Okay. Okay, sir. On that note, we need to end. We're completely run out of time. But this has been a very fascinating discussion. I'm sure there'll be more discussions in the future on this very, very important thing which has happened in this country. We will have to wait and watch what will be the outcome of it. Thanks to all my guests. Please keep watching. We'll come back with another issue of the big picture, same time tomorrow.